Άρα, έχω μάλλον εγώ το λόγο και καλωσορίζω όλους και όλες στον τέταρτο κύκλο της σειράς των διαδικτυακών διαλέξεων Εθνογραφήν. Όπως ίσως θα έχετε ήδη δει, ο φετινός κύκλος έχει ως γλώσσες εργασίας και τα αγγλικά και τα ελληνικά. Και με αυτό το σκεπτικό, καθώς σήμερα η παρουσίαση θα γίνει στα αγγλικά, θα μιλήσω και εγώ στα αγγλικά, καλωσορίζοντας όσους είμαστε σήμερα εδώ, μαζί με την ομιλήτριά μας, και θα πω μόνο ότι για λόγους οργάνωσης η συζήτηση μετά μπορεί να διεξαχθεί και στα ελληνικά και στα αγγλικά, ανάλογα με την άνεση που έχει ο καθένας και κάθε μία στο να συμμετέχει. Λοιπόν, I switch now into English, and I'd like to welcome everyone to this first online lecture of our online lecture series under the title ETHNOGRAFEIN, Critical Dialogues, Epistemological Challenges, Field Experiences, and Creative Texts. This is a lecture series that is organized since 4 years now by the Laboratory for the Study of Culture, Borders, and Gender of the Department of Balkan, Slavic, and Oriental Studies at the University of Macedonia, but also part of the organizing structures are two sub-structures of our laboratory, the Ethnography Club and the Club for the Study of Borders, Culture, and Diversity. Now, just let me remind us that this online series, since its inception in the spring 2021, aims to contribute to a critical and interdisciplinary discussion about, first, theory and practice of ethnography, second, the epistemology of research and the significance of embodied experience, and third, on the modes of dissemination of the knowledge we produce through our research to both academic and non-academic audiences. So now, this year's series is entitled Borders and Boundaries Revisited, Anthropological Perspectives and Public Engagement. So as we have already mentioned in the announcement of the online series, this year we set the study of geopolitical borders as our point of departure, and we try to examine diverse phenomena and processes, and also to see and use and discuss new methodological and interpretive tools to study politics, trans-border mobility, materiality, transnationalism, migration and refugeeness, border economics, nation-state policies, minority rights, and other issues that we can study with relation to the concept of borders and the bordering processes. Equally important is our intention to discuss anthropologists' potential to bring forth the subtleties of human voices, as we say, often overshadowed by the macro narratives, and create an inclusive, comprehensive dialogue in the public sphere that demonstrates the multiplicity of lived experiences. So our today's first invited speaker is Professor Olga Dimitriou. Let me just mention a few things about Professor Dimitriou, and then we will proceed with the presentation. So Olga Dimitriou is Professor in Political Anthropology at the Durham Global Security Institute and the School of Government and International Affairs in the United Kingdom, and also the program director of the school since 2019. She is a social anthropologist by training and has led projects on minority rights, gender, displacement, and refugeehood for the last 2 decades. Her current interests focus on activism in refugee reception sites in the Mediterranean, and more concretely in Spain, Italy, Greece, and Cyprus. Among her publications, she has authored 2 monographs: Capricious Borders, Minority Population and Counter-Conduct Between Greece and Turkey in 2013, and more recently, Refugeehood and the Post-Conflict Subject, Reconsidering Minor Losses in 2018. She discusses the concept of border and bordering practices or processes explicitly and implicitly in a number of her publications. Very selectively, I will just, and briefly, I will mention her monograph, Capricious Borders, which I just referred to, where she focuses on the region of Thrace, northeastern Greece, and examines the dynamics of community, power, and identity within the Muslim minority, more particularly in Komotini. With relation to the concept of borders, she introduces, even in the title, the concept of capricious borders to highlight the unstable and fluctuating nature of borders. But she also discusses borders as a form of governmentality, as a technology of governing. She also discusses analogic borders, for example, in the context of the Evros River border between Greece and Turkey. And she also discusses borders and with relation to subjectivity and processes of subjectification in the example of the Muslim minority. She has also co-edited a book with Rosita Dimova in 2018 under the title The Political Materialities of Borders, New Theoretical Directions, Rethinking Borders, published by the Manchester University Press. So both editors and authors in this edited volume discuss the relationship between materiality and politics, and argue that the distinction between materiality and non-materiality is blurred in the context of borders and border areas, and that this kind of blurring needs analysis and can really illuminate political processes and make them more visible. Finally, I want to also refer to one of her most recent publications, which is not about borders and bordering processes, but it's about how we write and how we use ethnographic data in order to write and produce knowledge. And I'm referring to her paper that has been published in the American Ethnologist this year, 2023, under the title Reconsidering the Vignette as Method, Art, Ethnography, and Refugee Studies, which in my view is something is a paper very interesting for those who wonder and discuss issues of how we represent the field, how we create narratives about the people we contact in the field. So in this paper, the vignette is a piece of ethnographic practice that can be described as a brief descriptive account, anecdote, or essay that provides a short episode in a play. So in anthropology, the vignette serves as a methodological question and a tool for thinking and writing. So it is a way to capture the everyday life and make small facts speak to larger issues in ethnography. If I'm interpreting and describing properly, Olga, some of the ideas in your paper. So I want to thank you very much for accepting our invitation and being here. So the floor is yours. Thank you.
Great, thank you, Yanni, and thank you for this really generous introduction. So I think what I'm presenting today is actually in relation to the paper that you were talking about on the vignette, is in fact the sort of explanation of where borders come in ethnographically. in terms of that work, because it's kind of, it's in a way the study out of which this thinking about how we do ethnography arose. So I think I need to share my screen first. Can we all see that? Okay, great. Okay, so I'll go right into the paper. The paper, in a sense, is about borders, because it's about an area that is very much defined by multiple borders, and I'll explain what these are. But it's about actually how these borders can be malleable in different ways. And I'm looking at the question of refugeehood, which is something that I've been looking at for a very long time. But considering older questions on the basis of this story, I realized that refugeehood is not just about sort of states defining refugees, but also refugees being able to define states. And this is what this paper tries to do. So the central question is, what can the treatment of refugees tell us about the states that mete it out? And we have in recent years many migration scholars, just to mention a couple, Polly Pallister-Wilkins, Alison Mounds, Catherine Besteman. They have argued that asylum processing extends colonial, racist, and carceral practices entrenched in global hierarchies. The treatment of refugees that this literature examines is helpful in locating the continuities of sovereign control over mobility and protection. But my question is, to what extent can the sovereign claims that underpin this governance be destabilized? So while states are conventionally understood as conferring refugee status on individuals, I contend that the protection of refugees equally defines what a state is. It defines the extent of its sovereignty, the quality of its democracy, its role in the international system, its collaborations with other states. So I argue that refugees define states just as states define refugees. And to do this, I closely look at one specific, arguably unique case in refugee law, where the questioning of statehood was prompted by the actions of refugees and judicial activists around them. And I show how these modalities of sovereign governance can be questioned and countered by agentic and resistive modalities of protest, vulnerability, and endurance. I guess methodologically, I should also say that being an anthropologist sitting in a politics department for the last 5 years, I've sort of spent a lot of time talking about how anthropology does things vis-a-vis other sciences, mostly politics. I've also, in terms of my refugee studies work, been looking at socio-legal questions in a way. So in a sense, what I'm presenting is also about the discussions, the dialogues that anthropology is having across this these fields. So I propose an analysis of refugee protection as an act of citizenship, and I'm following Engin Aysin's work here, by which I mean a field of contestation between practices that co-determine what is a proper refugee and what is a proper state. Now, in doing so, I make a methodological argument that such an analysis can help elucidate the role of law in activism through retaining rather than shedding the nuance and uncertainty that characterize such activism on the ground. And this is what anthropology has taught me in all of this. So the case I examine is called the Bashir against the Home Office case, also referred to in the literature as the Richmond case. It's a uniquely complex case as refugee case law goes. It involves an exceptional regime, that of the British bases, military bases in Cyprus. In its essence, it asks whether refugees residing on the bases can be resettled in Great Britain. But in the course of doing so, and essentially concluding that they can, it examines the sovereign status of the bases and finds that they are, in fact, colonial remnants, contradicting what was thought to hold true up to that moment. That is what the British government was arguing. So it is a case where unwittingly the call for refugee protection forced a redefinition of sovereign statehood. Now, the people involved in the case I examine, persisting and enduring as they did for 20 years, which is what the length of time that they stayed in the bases, are, I argue, perfect legal subjects. They endure and comply with the demands of the process. They prepare for hearing after hearing. They persist through appeals. They speak and hold their silence as they must. They make themselves available for the media. They retell the story over and over again. They wait for years on end, continuing to hope through the ebbs and flows of contradictory decisions that their justice will prevail. Such endurance both shakes and maintains the status quo, posing risks to state sovereignty as jurisdiction is redefined while delivering redress out of court, which is how the case ended. It was an out-of-court settlement. In this case, Richmond is a story of how agency and victimhood are intertwined, but also how actors, structures, networks, materialities are all imbricated in the process of seeking rights. Okay, so where is this place? Richmond Village is an area less than a square kilometer, located in the sovereign base area of the Gelia on the east coast of Cyprus. Alongside the base of Agrodiri to the south, the Gelia is classified as a British overseas territory. The base borders territories controlled by the Republic of Cyprus. It borders other territories controlled by Turkish Cypriot authorities, and it borders a UN-controlled buffer zone in an arrangement of checkered and at times contested sovereignties. And it also includes exclaves within the enclave of the base that are controlled by the Republic of Cyprus, as you see there, and so on. So this geography exemplifies Cyprus's decolonial condition of multiple and incomplete sovereignties marred by interethnic and political strife. Now, located in a corner of the Gelia base, Richmond Village, the circle in red, stretches over no more than 3 short roads and comprised, until 2019, a dozen or so households accommodated in prefab housing units. It has housed refugees from various countries who arrived on a boat on Cyprus in 1998, who were settled there temporarily at first by SBA, the British bases authorities, as well as their families who joined them. From 2011, some of the residents have been engaged in a legal battle with the UK government requesting their transfer to Great Britain, which they achieved through an out-of-court settlement in 2018. So this is the 20-year span, 98 to 2018. Remaining residents subsequently fought another legal battle starting in 2017 until 2020, through which they lost the right to remain in Richmond and were transferred to other prefab housing in the area of the base of a former bus station in the base. So over the years, the case has involved human rights lawyers in Cyprus and the UK, the UNHCR, the SBA administration, the UK Ministry of Defense, the UK Home Office, and the Republic of Cyprus. Now, according to court documents delivering the various judgments that make up the case, and this is the history of the documents that I'm talking about. In the afternoon of the 8th of October, 1998, a wooden boat arrived near the shores of Agrodiri, carrying 74 refugees from Iraq, Syria, Ethiopia, and Sudan. Whoever could afford the fee got to be on the boat that night. Akil, in his mid-60s by 2018, when I saw him, reminisced in his Richmond garden 20 years later. It was a cocktail of people, he says. Tak Bashir, who would later lead the legal case, swam to the shore and alerted the SBA authorities, who airlifted the rest of the group onto the base. They applied for asylum and were detained through the processing of their claims. UNHCR and the Home Office were called upon to provide expertise in assessing the applications, as the SBA held that the Refugee Convention did not apply on its territory. Now, some of the refugees were recognized in July 1999, others on appeal in February 2000. Others had their applications rejected. All, however, were subsequently moved to the more family-friendly, as practitioners described it, the Gelia base. It was to be a temporary measure. Of 23 houses, 10 were selected that were empty. 10 were selected to house the refugees. The homes had been used to house families of the Gelia military personnel in earlier years and were, by that time, in disrepair, vacant, and due for demolition. Over the next few years, some of the residents were joined by their families who had been left behind in '98. Families expanded, others were created anew, some split. People had children on the base. Lawyers I interviewed explained that some women had given birth at home, some at hospitals on the base, some in nearby hospitals in the Republic of Cyprus. So these contingencies would prove significant later. It meant that the cocktail of people also encompassed a cocktail of statuses. This situation, for the most part, did not seem to make a difference in villagers' daily lives. Some were refugees, some were failed asylum seekers, some were and remain stateless. And this concerns the children who were born on Republic of Cyprus soil, who weren't resident in the Republic of Cyprus subsequently, and were stateless because the Republic of Cyprus does not have jus soli law. So over the years, adults tended their houses and gardens. They raised chickens. I'll show you a few pictures. And other animals. They saw irregular work. They created routines of sharing coffee in the evenings and stroll in the afternoons. And as one lawyer tells me, for whatever squalor it might otherwise represent, Richmond became a home. With time, Richmond residents, having started out as a cocktail of people, on that October night of '98, were also transformed into a community. But it was a community without rights. They lived on welfare and unbilled amenities, uncontracted work, struggled with shopping from the next village and nearby town, received parcels from visiting well-wishers, their visitors often being people concerned with their case. The teenage children in Richmond commented on how they visited school friends at the nearby village, Greek Cypriot village, but never had them over in return. They lived, and indeed some died, under the state's radar. In its exceptionality, Richmond Village was, and still is, also a demonstration of how lives are lived under precarious citizenships, as Noura Lori puts it, and liminal legalities. So in the early days and years, as refugees received monthly allowances and food deliveries arranged through the British bases authorities, the fact that responsibility lay with SBA and British authorities was undisputed. However, in 2001, when some residents sought visas to settle in the UK, they received refusal letters from the Home Office. Now, back in 2001, this was a time, remember, when Cyprus was in accession negotiations with the EU. And this process prompted the UK to conclude a memorandum of understanding with the Republic of Cyprus, rendering the latter responsible for refugee protection of people who might arrive on the basis from then on. So while the Republic of Cyprus insisted that this would not include the Richmond villages, there was another understanding, we hear from the court record, reached in 2005, that said otherwise. This understanding, not officialized in writing, agreed the transfer of Richmond refugees to the Republic. This was an early version of what have since become routine bilateral agreements regulating relocation, resettlement, readmission of protection-seeking populations, and which we increasingly see play out now in what scholars are calling migration diplomacy. So although flimsy in its legal form, as many such soft law agreements are, this understanding had severe material implications on the lives of Richmond villagers. The children were moved to the Greek school. Welfare payments were transferred to the Republic of Cyprus authorities, initially subsidized by the SBA, and later discontinued to be reinstated in the course of the legal proceedings. The school, which you see here, and its playground were demolished. Residents began to receive visits by SBA officers offering to transfer their refugee status to the Republic of Cyprus, which would secure them work permits, and, as some of them hoped, travel documents. At first, they were told their applications would be examined anew, but that they should expect a positive outcome. They refused to take the state at its word, and then were told that the applications would be recognized automatically. Asked about prospects of eventual citizenship in the Republic of Cyprus, they were told their residency clock after 7 years on the island by now would start anew. What the court record describes as a carrot and stick approach was implemented with increasing persistence by the SBA and rather shaky commitments by the Republic of Cyprus. In January 2010, SBA officials served the villagers eviction notices, and this is what spelled the beginning of the legal case. Now, through the course of these developments and later the legal case, Richmond residents continued to endure, protest, plead, and comply. Some took up what was offered and sought status in the Republic. Some moved there initially and then tried to return. Some made it back, others didn't. Some demanded their rights through protest, marching, camping, staging events outside the SBA police station and main roads in the area. As the case progressed, the differences in status began to make a difference. Recognized refugees began to see their prospects more clearly as advocates visited and took statements. Those who were not recognized were offered alternatives, moving elsewhere on the base, being offered possibilities in the Republic, gaining BOT citizenship, that's British Overseas Territories residents, which allowed them to travel to the UK, but excluded them from the right to abode in the UK, to live in the UK. Now, children grew up and moved away. Others went to a private university in the area. Still others married and brought spouses in. Through all this time, uncertainty continued to have a toll. An assessment of the mental health of litigant families commissioned by the UNHCR in 2013, and another of social conditions by a social worker on behalf of the UK advocates in 2015 indicated chronic and serious issues of depression alongside a host of other ailments. Incidents of domestic violence and a matricide make up a parallel legal record of the Richmond community. In those other criminal case documents, the uncertainty of residence, status, and the future feature as possible mitigating circumstances that the court considers, even if it eventually dismisses them. It is from within these imbrications that we must understand the relationship between the redefinitions of state sovereignty that refugees achieved and the forms of agency that they mobilized in doing so. So what is the case about? In September 2011, when Richmond refugees appealed their evictions through the case of Bashir against the Home Office, the SBA Agrodirty Court asked, does the 1951 Geneva Refugee Convention currently apply to the sovereign base areas? The answer was sought in the status and nature of the SBAs. Are the bases, judges successively asked in 4 iterations of the judgment, the ones that I've shown you before, are the bases A, relics of the old colony of Cyprus, that is what was left as the rump of the British colony of Cyprus after the Republic of Cyprus was created, or B, are they a newly created political entity? So from its inception, the case was not one of refugees calling on the state to protect them. It was one in which the state was called to define itself, to delimit its sovereignty, and to prove its legal status. The refugees were, in fact, in a co-constitutive relationship with the state on delimiting its jurisdiction and responsibilities. Now, how does this work? So as I said in the paper, I'm talking about, I see 3 modalities in operation here. The first set is modalities of sovereignty through what I call colonial humanitarianism, exceptionalism, and diplomacy, and modalities of agency on the part of refugees. So I will go through what I mean by this in turn. So the colonial humanitarianism aspect. Now, iteration after iteration, all the way to the Supreme Court, the judges studiously explain how Cyprus was ceded to the British from the Ottomans in 1878, how it was then annexed in 1914 during World War I, how it was fully recognized as a colony in 1923 with the Treaty of Lausanne, how it became independent in 1960 with the exception of the 2 SBAs, how those bases were also exempted from accession to the EEC when UK entered in 1973, and again from EU membership upon Cyprus' accession in 2004. How today the bases play a role in the UK's global military engagements alongside other bases with which they should be treated equitably, the court says, and how the bases are set up as a cluster of spaces accessible to different degrees by military personnel, their families, Cypriot nationals, expats, and Richmond villagers. And finally, how the likelihood of further refugee arrivals on the Gallia shores is tempered by the fact that the base borders the UN buffer zone and the territory controlled by Turkish Cypriot authorities, which is a legacy of the Cypriot conflict. So this history that the court record records again and again of multiple and diverse statehoods, and not the personal story of persecution that would normally abound in refugee litigation, is what is of essence. So in briefly considering the refugees' flight, the court is not concerned with how refugees left, but rather with how they arrived, sketching the contours of what I call a colonial humanitarianism. So, and it says, when the appellants first arrived in the SBAs in 1998, the SBA administration were obliged to accept responsibility for them. The alternative was to abandon them to the waves. But because it did so, because it has provided for their basic needs for many years, and because it has granted them refugee status, that does not mean that it has any more responsibility for them than it did in 1998, and it does not mean that it has assumed responsibility under any treaty, convention, or ordinance. The responsibility has always been humanitarian, but the appellants say that it is more than this. Okay, so this was the position of the UK government from the start. The convention did not apply to the bases because the colony and its legal apparatus had ceased to exist. But as a caring state faced with an emergency, their authorities saved people from drowning. Now, in that pivotal paragraph where judges accept the government's claim, the convention is at once summoned and obliterated. The SBA administration, the court heard, acted, quote, in the spirit of the convention, but had not applied it themselves. Again, a quote, they sought the assistance of the UK Home Office and UNHCR, so that should prove that it did not apply. They submitted to the spirit of the convention as a moral rather than legal imperative. And yet, in insisting that this responsibility has always been humanitarian, not assumed under any treaty, a separation is made between humanitarianism, read as somehow lying outside the convention, and something more than this. So this is the line between hard law and moral imperative, or, I think, the substance of protection and its management. The employment of tools and institutions directly involved in the application of the convention, that is UNHCR and the Home Office, to determine refugee status would indicate that what was at issue was not merely saving people from the waves as humans, but protecting them as refugees. So it is exactly because it considered itself the state that it was, that is a liberal, humanitarian, democratic state, that it also required a managerial process to determine, quantify, and apportion the protection that an otherwise humanitarian imperative necessitated, supposedly beyond and outside the law. So within the assumption that the end of colonialism obliterated the convention lay a neo-colonial approach to ascertaining exactly who it is that one has saved, and presumptuousness that exceeds mere humanitarianism as universal and unqualified imperative. Separating this assumption from responsibility and therefore extricating the spirit of the law from the letter of the colony necessitates recourse to exceptionalism. So this is now the second modality in which this idea operates. Now, the second task of the court is to determine exactly what kind of overseas territory, BOT, the bases are. Initially treating BOT sovereignty as uniform, the Agrodiri decision speaks, this is the first decision, speaks of administrators who double as governors and commanders, connecting the administration to the crown, but politically, quote, disconnecting it from the UK government. The MOU between the SBAs and the Republic is declared an international agreement, albeit one that does not bind the UK. A manual written by Foreign and Commonwealth Office lawyers is consulted to delineate fine differences. Points are argued extensively regarding the distinction between military and political spheres, legal and constitutional relations, dependence and independence from the UK, and one lawyer tells me, believe it or not, copious case law about the Queen of the UK being separate from the Queen of the bases. She said this with amusement. The state has to account for itself. Now, in subsequent judgments, BOT comparisons are extensive, so the different overseas territories between them, most notably with the British Indian Ocean Territory, and this is where the acronyms get complicated because now we're talking about the BIOT. The Bankul 2 case, which refers to the Indian Ocean Territory, is studied for its establishment of the BIOT as a new entity when the islands were excised from Mauritius in exchange for the latter's independence, a practice that the International Court of Justice has declared illegal, questioning the decolonization process of Mauritius. The Bashir case, unexpectedly, and in light of this court decision on Chagos, speaks directly to fundamental decolonization questions, as one lawyer noted. So she says, I heard at a meeting a legal advisor to the Republic of Cyprus government using the Bashir case to say, see, the bases are residual and show they do not have sovereignty. So you can take the decision of the UK Supreme Court and shift it slightly depending on what purpose you want to serve. And it is even used on matters pertaining to the Cyprus question of the basis. And they want to link it to the decision of Mauritius to say that colonial residuals are no longer tolerable, etc., etc., the lawyer says. So enforcing a redefinition of the state and its sovereignty, Richmond refugees have forced the state to reincorporate the convention, not merely as spirit, but also as substance in their extension of protection. The moral responsibility and humanitarian duty was, in other words, intertwined from the very beginning with legal procedural issues between the refugees and the UK, as well as between the Republic of Cyprus and the UK. The refugees' lawyers were thus able to draw on the exceptionality the state claimed for itself and question its very foundation. In order to put the focus back on the substance of protection beyond the spirit of the convention, sovereignty must be dissected and questioned, a process that requires that the ghost of colonialism be conjured up. So in that questioning, the spirit of the convention rewrites the letter of the colony, and as I next show, does so by putting soft law diplomatic agreements under erasure. So there's also a parallel story here of capricious diplomacy, which is this. Even without a conclusive decision, the Bashir case questioned the quality of outsourced protection afforded via documents such as the MOU between the SPAs and the ROC, the Republic of Cyprus. Through close scrutiny of the memorandum, the quality of diplomatic contacts between these two entities and between the UK government departments is assessed and found wanting. The promises made, withdrawn, and refused by the Republic of Cyprus are enumerated. Now, the lengthy examination of the Memorandum of Understanding traces the temperamental stance of the Cypriot Ministry of Foreign Affairs, initially reluctant to include Richmond refugees, then agreeing to extend it, and then reneging again. Now, this diplomatic history, though, is intertwined with a secondary tracing of SPA UK diplomacy, so the relationship between essentially the Home Office and the British bases. Soon after the refugees were recognized in 1999, the MOD, the Ministry of Defense, had written to the Home Office that we frankly see no realistic alternative to their resettlement in the UK. There is the question of precedent to consider, as you pointed out, but I think we should be careful not to make too much of this. It was a debate that would continue to be had between the two UK government departments all the way to the conclusion of the case. A memo from 2001 is quite interesting. It contains various handwritten notes evidencing the battle between departments. The UK Minister for Europe had written, "I will not support relocation to UK. This is not on politically." While an unattributed note read, "An eventual offer of asylum in the UK seems inevitable, but will mean a battle with the Home Office." This is written from the point of view of the British bases. And a third still concluded, yes, they should be led into the UK, but ministers have said no. Now, as this palimpsestuous record, as Stoller would call it, becomes evidence because it's actually, you have this paratext being now made part of the legal record, the coherent story of sovereignty begins to fray. The questioning of statehood that the case put in motion extended to multiple states and their relations. So it is not enough to ask only what this state is in order to elicit its refugee obligations, but also what kind of relations it sustains with other states, in this case, the Republic of Cyprus, and what their statehood is like, and indeed their relations with other entities, in this case, Northern Cyprus, in the absence of a post-conflict agreement. Are they reliable interlocutors, whimsical, politically expedient, humanitarian? The Richmond refugees do not call on just one state to account for itself, but a system of states that apportion protection amongst themselves. Now, the scrutiny over the capricious diplomatic engagements that put such apportioning to practice is instructive about the myriad microprocesses through which the letter of such agreements is belied in the knowledge of and with the complicity from the states that conclude them. The multiple diplomatic efforts recounted in the different directions within and between states are at once affirming of statehood, upholding proper processes of recording, noting, communicating, etc., and seditious, as Kostas Konstantinou has said, mocking and doubting the virtue of the exercise. Now, much of this parallels what we have recently seen unfold in the debate over outsourcing protection from the UK to Rwanda and other states, or indeed what unfolds in territories like Ceuta and Melilla and the agreements between Spain and Morocco, or in Aegean islets of disputed sovereignty and the agreements between EU and Turkey. The Richmond case shows, I would thus suggest, the futility of the migration diplomacy approach that scholars are now turning to, of which new legal instruments like the Global Compact on Refugees and on Migrants and the EU Migration Pact can be seen as an extension. The Richmond case is suggestive of how such grand policy shifts entail not just risks for refugee protection, but also risks for the states offering and denying such protection. Now, what are the modalities through which this is countered? As much as the Richmond case celebrates the successes of transnational litigation activism, as I said, it involved lawyers both in Cyprus and the UK, it is also instructive about the modalities through which such activism unfolds, which are more mundane and often less visible than grand narratives of strategic activism. Over the years, Richmond refugees have protested their living conditions and denials of resettlement, but they have also endured those conditions and have at times succumbed to them. These modalities of protest, vulnerability, and endurance are important to acknowledge both in their appearance and disappearance from the legal record and in the narrative of Richmond residents if we are to appreciate the ground level dynamics and context of litigation activism. So I start with protest. Protest is conspicuously absent from the court record, and from here on I'll be showing pictures from Richmond Village since 2018 onwards. So the protests are absent from the legal record. And these are protests that Richmond villagers staged at different points. The 2011 decision makes a brief reference to protests in early 2007 against eviction notices. And it says, following this protest, these notifications were temporarily withdrawn. New notices were served in 2010 when welfare was also cut. From Fosquet, who is one of the judges in the later judgments, he quotes Tag Bashir directly, and we instead learn that this very briefly described protest actually went on for weeks around March 2007. So the protesting refugee remains in the legal record a vulnerable subject. Now, outside the legal record, other protests in Richmond have been treated with less humanitarian sympathy. A second protest in 2007, media reported at the time, was met with demolition of the momentarily unoccupied protesters' homes, presumably forcing them to relocate to the Republic. Now, this enforced relocation is muted in the record that notes only that, a quote, of those who have voluntarily relocated in the Republic of Cyprus, many are now working there. Their children are in full-time education. They have all the appearance of having integrated well, and none has been deported. Now, another protest in early 2016 was staged by one of the rejected asylum seekers who set up a tent opposite the SBA police station protesting the decision. The precarious situation it had created for himself and his family and the living conditions they were in. This was the longest but least reported of all protests I collected information about. Richmond residents recalled it readily in 2018 as having lasted for months. Its effects were uncertain. If anything, it seemed to have made matters worse. For those involved, it was the toughest part of their lives in Richmond, and in return, some of them felt that authorities were now more disinclined to heed their plight than before. Seeing the Bashir case progress successfully during the time they protested, they wondered if their exclusion from the offer, the recognized refugee squad, was targeted and retaliatory. So the different acknowledgement and responses to the protests that Richmond residents staged over the years foregrounds and celebrates a submissive subject who petitions over a rights-demanding subject who scales buildings and puts up tents. The difference hinges on perceptions of vulnerability, and this is another agentic mode in a sense. As the case progresses, the refugees come increasingly into view as legitimate actors with voices, names, bodies, concerns, and rights, just as sovereignty recedes from you, becoming increasingly fuzzy. And even though they're above all vulnerable actors, this vulnerability emerges beside their agency. It centers largely on the living conditions at Richmond, the lack of proper infrastructure with only rudimentary water and electricity supply, the presence of asbestos in the housing structures, and the effects of this long-term condition of precarity on the mental health of residents, both adults and children. The initial 2011 decision had concluded with reference to 13 difficult years, difficult both for the appellants and for the SBA authorities, it says. In his judgment, in 2016, Judge Fosquet distinguishes sharply between these difficulties, citing the 2013 UNHCR Commission psychological assessment, which had found that each one of the refugees, including children, suffer severe psychological problems and stress, some of them suffering severe depression. A social worker's report from 2015 concurs. They feel as if they have been subject to emotional torture at the hands of the SBA authorities. But while all sides agree on the detrimental effects of these conditions, the agency of the litigants in accepting solution is differently portrayed. The Agrodiri court summarized in 2011, this is the very first decision, the interactions between the refugees and the SBA authorities as made up of, quote, many meetings, some noisy and unruly. The refugees sometimes heard only what they wanted to hear. The only promises that were made were that efforts were going to be made and were made to relocate them to a third country and that they could remain as temporary residents until they could be relocated. So in this reading, vulnerability is acknowledged, but the agency that attends it is dismissed. There is a qualitative difference between the initial decisions and later ones in the ways the refugees were heard in court. One of the lawyers recalled the initial hearings in Agrodiri vividly. She says, I had a sense of litigants present in court becoming agitated as things about them were being said in the courtroom and wanting to jump in. I would gather them around during each and every break and repeat every single time, you don't talk. Another lawyer reminisced about the long statements being taken from Richmond residents in the preparation of the case, making sure everybody had said what they wanted to say and representing this in evidence. It was what the early stages of the process had not allowed them to do. So what this court record does not report, though, is the even worse conditions endured by the group of residents that had not been recognized as refugees and therefore not being litigants in this case are invariably described as failed asylum seekers, or residents. A later case appealing against relocations of the group that was left behind, which was filed at the Agrodi report in 2017, considered these living conditions, but nevertheless rejected the case conclusively. Respectively, the matricide case that I mentioned earlier, which was also heard around that time, noted but also dismissed the pervasive uncertainty that permeated the lives of those concerned as mitigating factors, even as it left implicit a question about the mental health of the murderer, who had refused engagement with the proceedings. And I'm reading from the case. There appears to be suggestions that there was conflict within the family regarding finances and their legal status, together with a sense of hopelessness regarding their long-term position, sense of identity, and attachment to any community. Although the family have resided for approximately 20 years in Cyprus, they still have no official status, rely on financial handouts from the government, and they apparently maintained a hopeful fantasy that eventually they would be able to move to another European country that has to date never progressed. So these are vulnerabilities that may be noted, but are ultimately dismissed. They cannot have bearing on the lives of people who have not been recognized as refugees. In the Bashir case, an empowering decolonial refugee persona emerges, predicated on a carefully curated vulnerability that nevertheless successfully unpicks colonial presumption. But it can only do so on the predicate of refugeehood and not on any other status. So this is a significant difference between the protection the convention can afford and other complementary statuses, the protection that such complementary statuses, not under the convention, in fact, foreclose. And it is only on these grounds that a happy medium of agentic vulnerability, which is not protest to be crushed or inert desperation, can be achieved. And to move on to endurance, the material conditions that render Richmond villages vulnerable, the social workers report sites exposed wiring, cramped conditions, damaged wall panels, major disrepair that had been accumulating for 10 years, are also tests of their endurance. Now, Judge Fosquet's 2016 again finds that these conditions, quote, make it quite plain that any decision that prolongs the period the claimants, including their children, remain there affects their family and private life. He acknowledges, another quote, that many other refugees around the world may themselves be affected by similar, analogous, or worse deprivations, but finds this, quote, irrelevant to this conclusion. So this last comment indicates the point at which agentic vulnerability transforms into endurance, marking the difference between what is acceptable and what is not. The agency that comes with endurance might, under other conditions of refugees around the world, have been celebrated as resilience. That is the ability of populations to plow through hardship, battle the forces of nature, and face disasters. This discursive shift has also allowed the normalization of such conditions of deprivation through an empowering spin. And this is Julian Reed has a beautiful critique of this discourse on resilience. The Bashir case creates room for resisting this normalization in the acknowledgement that people, in this case refugees, are entitled to more. So if agentic vulnerability renders a resolution urgent, endurance is the resistive force that underpins their claims in the first place. Vulnerability is in these terms easier to see and name in the materialities that surround Richmond and its houses, while endurance is an affect that is puzzling and ambivalent. As Lila walked me through the landscape of rusted road signs, which you've been seeing before, the gutted bus stop, garbage heaps, the demolished school and its playground, fences and barbed wire, and rugged roads in the summer of 2018 and 2019, she pointed to the places her group of friends had inhabited after school walks. The cliffs where they practiced yoga, the school ruins where they played with the younger kids, the paths they took back home through the shrubs, occasionally having to avoid local dog walkers or joggers. An air of nostalgia in 2018 hovered in this tour as the long-awaited departure to the UK was now imminent and about to break up the group. Lila was ambivalent about this place that was home. She and her friends took its objection in their stride. They spoke of close friends they visited often in the village up the road and who never visited them back. It would be good to relocate, they reasoned, but also difficult. This is what constituted endurance as an agentic mode of being for the villagers, persisting through the whims of authorial actions, taking the state at its word, living through the law and its procedures day in, day out for 20 years. It is ultimately how claiming a simply livable life becomes a matter of pained resistance and a question of taking on a post-imperial state. This is the process of becoming perfect legal subjects. So before I close, just a note on what I mean by perfect legal subjects. The record's twists and turns that derail the linear tracing of documents from one department to another are caused by events that the court process only cursorily mentions. It is these modalities and their context that collectively make up perfect legal subjects. In being saved from the waves, at risk from asbestos fibers in their homes, paperless and jobless, and the threat of eviction, and in prolonged precarity, as children born and growing up in limbo, and as adults with limited linguistic skills in their surrounding community, and as a community of people under collective and continuing psychological stress, the refugees are constructed in the report of legal experts, social workers, administration officials, and indeed in their own words, as vulnerable subjects in a long-term humanitarian emergency. What the refugees unexpectedly did was to pursue the case to the end, to defend their demands for the rights that they wanted in the terms that they were entitled to for 2 decades. The agency in this form of subjectivity is fraught with the struggles of the mundane. There is in that inconclusive trial and the halfway negotiation that leaves no precedent and little citability, a stance that has been won over what refugee rights substantively are. That endurance of being perfect legal subjects is the price for vindication. It is an exacting price, nevertheless, which not everyone has been able to afford. People have moved elsewhere on the island, as I said. They built better or worse lives. They battled with decisions to stay or go. They battled with their families, at times violently. The 2 criminal cases in the court record also show the injurious and fatal nature of that condition of endurance and its failures at protection. And there is, of course, protest, which notably does not arise in contradistinction to vulnerability and endurance, but from within those conditions. So in this sense, the 3 forms of agency together point to some of the many ways in which the making of agentic subjects requires the formation of perfect legal subjects, which is to say that it comes with institutionalization within the refugee regime. A redefinition it had initially rejected, and which, in combination with the International Court of Justice decision that other refugees have imposed regarding Mauritius, threatens the viability of the colonial British overseas territory. The committed lawyers who exploited the gaps of the exceptional status of the bases and the lack of implementation of various agreements drew, together with the refugees, on legal possibility to get an exceptional regime to abide by the legal obligations of normal states. In doing so, They showed that the moral responsibility and humanitarian duty was intertwined from the very beginning with legal procedural issues and political protests. Their activism simultaneously exploited and reinterpreted the law of exceptional and colonial regimes, while also combining it with the spirit of the legal instruments that are meant to offer protection to refugees by normal states. It showed how colonial spaces and law can deny refugees their rights, but one can play colonial law arrangements to make way and gain redress, albeit at a cost. To do so, Richmond refugees have paid the price of waiting, of enduring, of an out-of-court settlement conclusion that may have limited the promise of the case, allowing states to subsequently close the gaps it revealed. They have paid the price of becoming a community out of a cocktail of people and of leaving that community behind. As Richmond now disintegrates, those left have been unable to score the same victories in court. The state, for them, does not need to delimit itself for lesser protection statuses when the force of the convention in spirit or in substance is not at issue. Those who remained have been moved elsewhere on the base, encouraged yet again to relocate to the Republic and start over. Their houses have been demolished. Of the village I saw in 2018, only the last 3 houses remain standing by 2023. Everything else razed to the ground. Residents lamented the friends who left and their own condition, even as they looked forward and made plans for a move to England in upbeat expectation. Now settled in Britain, some of the Richmond residents wrote back to friends about new plans, schooling, and the rain. It was a door and now it's closed, and a new one opened here, one of the resettled refugees explained to me as he articulated the reluctance to revisit the story. There was little lament for home and community in this quote, and implicitly little wish to go on verbalizing his legal subjectivity. The making of perfect legal subjects is an aspect overlooked in studies of refugee mobilization, less grand and certainly less visible than protest, yet not by any means disempowered in the way that vulnerability is often portrayed. It is a subjectivity that cannot be celebrated, as its redemption and resistance are always uncertain. Yet, current trends in the governance of refugeehood seem particularly pertinent to this modality. Parallel obfuscations of colonialism to what has been described here are now seen in approaches to the rescue of migrants in the Mediterranean. States' disregard for the law becoming evident in Europe through increasing visibility of illegal actions such as pushbacks are prompting greater emphasis on counter practices that take the state at its word, not only in law, but also in ever complex techniques of documentation like counterforensics. In showing how refugees and states are constitutive, the Richmond case may well foreshadow what lies ahead in the continuing management of asylum as a field of crisis. For in the same way that Richmond refugees inadvertently, perhaps, have put to question the UK's decolonial process, refugees bound for Rwanda under the most recent Nationality and Borders Act are currently putting in question the UK's commitments to the ECHR, the European Convention on Human Rights, and even the UK's membership of the Council of Europe. The current global assault on refugee protection seems to pit sovereignty against mobility, and recent judgments like the European Court of Human Rights 2020 decision on Melilla are veering towards bolstering the first, because it recognized, it essentially said that the state had a right to violently push back the two claimants. However, the Richmond case shows that the immobility being enforced onto people denied their rights holds significant risks for sovereignty too. The production of perfect legal subjects arises in the folds of this contestation as the flip side of activism successes. Far from being an aberrant situation, it shows the possibilities that unfold in increasingly multiplying locations in the Mediterranean, in the Pacific, in the Indian Ocean, and beyond. As emergency states proliferate, migration policies become more restrictive, and political dynamics more polarizing. The production of perfect legal subjects is the costly response to such imperfect quasi-legal states. Thank you.
Thank you so much, Olga, for this nuanced analysis of these processes. And as you said, it looks like this is a unique case where governance, sovereign governance is undermined in this, it looks like a relatively successful way by activists and refugees. So I think we can open the floor for questions and discussion. For those who attended, who joined us a little later than the moment we started, I have just said that we can have the discussion and the questions both in Greek and English, depending on the confidence one has in using either languages. So technically, it would be helpful so that you raise your digital hand, and you can also write questions in the chat space. So feel free to ask and comment. Helen.
Yes, Olga, thank you very much for this rich analysis. My first reaction would be, with all this proliferation of exceptions, in the end, who would be the citizen? Who will have full membership and of what sort? Because I think that less and less will be enjoying this traditional, in our mind, citizenship of granting rights of social and economic or political membership. Well, my question though would be on the methodological front, how you did it. I saw your emphasis on the photographic, the visual aspects, and I would like you to elaborate a little bit about that. How they help you to navigate, if you like, these exceptions and this complex of different scale research through the materialities of this of the terrain.
Yeah, thank you, Eleni. Yeah, okay, to address the first question, I think it's very pertinent, and I think this is partly why I find the theoretical framing around acts of citizenship so interesting, because that's that's a way of shifting the focus from the status as such to the actual act. So, what I find interesting about what Engin Aysin does is that his acts of citizenship is not about who is a citizen and therefore who is not a citizen, but what it is that constitutes, what does the act do, and how do we analyze the act. So in a way, it's also through the theory a way of destabilizing exactly what you're talking about. Also to say on the back of that I think one of the lessons that maybe I didn't kind of highlight enough here is this thing about exceptional situations, because in terms of what we now see states do as a sort of way of denying protection is to create all these exceptional cases. So we see Australia doing it with Nauru, and sort of states devising way. We see it in Mayotte with France. So there's a whole kind of web strategy of sort of creating exceptional state places so we can kind of do what we want from the state's perspective. And I think in terms of the law, what this case does, perhaps most importantly, is to actually say that the exception has its limits, and to basically say that, okay, if you're claiming that you're exceptional, let's open it up and let's actually see, are you that exceptional? And in the case of the British spaces, they're saying, well, no, actually, you're not an exceptional territory. You're just a colony. The colonial regime, which is, we have decided as an international community is not acceptable, and so on and so forth. So I think this is the key message politically of this case, that exceptions have their limits. In terms of the methods, that's another really interesting question. I mean, I showed a lot of visuals, but I didn't go out seeking to do a visual ethnography. I was helped, and this is what the vignettes article does as a side story to this work. It did start out as a collaborative. Well, it started out as an interest, and along the way, I found an artist who was working in the area, and I was introduced, in fact, to Richmond residents through her, and the process of starting to think about what vignetting might be about in terms of ethnographic methodology really started as a question of how people outside of anthropology might be doing ethnography without necessarily calling it that. So that's a sort of side story to the to what I tried to do in the vignettes. And as I said at the beginning of the presentation, I've recently been spending a lot of time thinking about how people across various disciplines are doing things in similar ways or in different ways to what we do. And I've been thinking a lot about how people do ethnography and do it not in the way that we understand ethnography. So, you know, you get people in other disciplines sort of doing ethnography that we think is not really that. But then with Effie Savidis, this artist, I kind of came against the opposite question. What about people who are not really going out to do ethnography or claiming that they've done ethnography, and yet what they do for their work is that they're there on a daily basis. They kind of talk to people from morning to evening. They know their sort of lives inside out. They just do it because they've, in their words, they have friendly relations with these people. And essentially, what she described as doing with the villagers for her art project was, as far as I could tell, very ethnographic. And then in the process of doing that, I think I also developed a way of looking at Richmond in that way. So I think those pictures are perhaps a result of this seeing in that way. This paper is very much methodologically, I think, conventional instead of reading the legal record. So it's not so much the ethnographic bit of the research, although I think what it helped me realize was that you can't really understand what is going on or sort of gain the nuance in sort of telling the legal story unless you do have also that ethnographic backstory. So in a sense, I'm not quite sure which approach is in the driving seat, whether it's sort of the legal record or the ethnography kind of being prioritized here. But I think what I try to do is to make them work together and to have one speak to the other. I think equally, I wouldn't have been able to understand what was going on just by speaking to people and doing the more conventional ethnography, because it wasn't very clear where the legal story was going. And I couldn't really tell from what the people were understanding of the process that this was all this sort of relations between states and the various communications between different departments, which of course the refugees didn't have access to, really. I wouldn't have been able to be given that story just by speaking to people on the ground, but equally, I wasn't able to understand what this felt like and the toll it took just by reading the record. And that's the message really of the paper.
Right. Thank you, Olga. Anyone else who wants to pose questions? Raise your digital hand. Okay, until
On the chat.
yes, there is one at the chat. I see that. Okay, Thomas, maybe you can just address your question loud. Thomas, go ahead. Thomas, yes, go ahead. Anyway, I'm not sure. I cannot hear you. So the question raised by Thomas in the chat is that his question is, where are those people from the SBA back in 1998 located today, and how do they interpret their today's status?
Yeah, I mean, as I was saying, they're in different places. So some of them are still, well, very few of them are still in Richmond. Some of them are still on the base, but in a different area of the base. And the successful litigants are in England, mostly in England, some of them in Scotland as well. How they interpret today's state? I mean, variably. I mean, some are happy with the way things turn. Obviously, I think in general, the people that succeeded in having been relocated are consider this a victory. They do consider it an uncertain victory. It's I'm not sure if I think I've hinted in the paper version of this, but I elaborate elsewhere. They have been asked at various stages in the process why they do this, why they have endured, and they have said, and this was said to me by their lawyers, that they at various points have said, our lives have been spent now. We don't have actually much to look forward to, but we did this for our kids. So at least our children now have a future in the UK, and this is what they seem to keep as the important bits from the story. The people who were left in Cyprus, it's as I said, you have various shades of success or not in how they read their story to have unfolded. A lot of them have moved to the Republic of Cyprus. A couple of families have in fact moved to the north of Cyprus as well. Yeah, I've also not spoken to every single one of these families, but I do, even from the secondhand accounts and from the people that I've spoken to, I get a very patchy picture of how they assess the situation.
Okay. Right. Before there is another hand, I will take advantage of my privilege and also express some thoughts and questions, Olga. I'm currently working on issues that relate to borders, performative culture, and touch upon, of course, nationality, citizenship, and minority rights. In the case of Greece and North Macedonia. And I was thinking about a lot of parallels and analogies as I was listening to you and also reading earlier your paper. I see that in the case of refuginess here or refugeehood, it's minorityhood in my case, and there we have states and other supranational organizations being involved. We have activists on minority rights in this case, in my case. And of course, there's a great deal of agency. Of course, there are asymmetries of power, as we know in these occasions. And I was wondering, one thing is, I mean, coming to my questions now with regard to your case, I was wondering, you touched upon in your answers on this, but still, I mean, these people are received when they arrived in Cyprus as, a labeled othered community, refugees. Despite the fact that they come from different countries and continents, and there are different gender and ages. There's kids too. So they're placed there and they grow, I guess, or I imagine, as a community, also within them, themselves, and also seen as, and I suppose that within this legal process, they are constantly perceived as such. And as you very interestingly said, that they are then portrayed as the perfect legal subjects in the documents. So I was wondering if you can elaborate a little more on this sense of community that is developed in different ways, but then it is portrayed in specific ways in this procedure, the documents, and whatever. And the other issue that I'm interested in is the idea of activism. I mean that I wonder, I'm thinking in cases of minority rights, not only in Southeast Europe, but also in other parts of the world, there is this, which you call strategic activism, but then I wonder to what sense can today's procedures, legal procedures, be dealt with by what forms of activism? It sees that this is an exceptional case where, I don't know, very plainly put, the people who were guiding, I mean, the legal activists, lawyers or whatever, they just saw exactly what they had to do. Okay, I stop here, so please share your thoughts. Yeah, thank you.
Okay, I'll take the last point first. Actually, they didn't. So one of the points I'm trying to make here is that the lawyers didn't, in fact, see very clearly from the beginning what they needed to do. In fact, what I was told is that the case began. It was almost dismissed at the first stage by the accredited court. So this was the court of the military base, who completely went with the narrative of the authorities. And there was one dissenting opinion in that decision. There was one judge who basically articulated something different, and that was the sort of rather flimsy even event or opportunity that opened the possibility of the next stage of the proceedings. My understanding is that at that point it could have gone either way. So one of the points I'm trying to make is that when I read the literature on activism and more specifically on mobilization more broadly, I think what we often try to tell is a story, is a sort of is a story that's where we can extract lessons. So what is it that one can do well so that we kind of continue to get this positive decisions, this sort of success stories. I think so. There is a difficulty in, and I get this from the lawyers as well. I mean, to what extent can you consider this a success story? Definitely the people who were asking to be relocated were relocated. As I said, there are important lessons here. There are important, and I think the biggest of these lessons is that all of this process entails risks for the state, because so far we, in the way that we've seen states behave, it's as if there is the ball is completely in the court, and it isn't. But in a sense, I think if we look at it from a bit more of a cynical perspective, the refugees may have put the status of the bases in question, and they did, but ultimately in the wider political chessboard, I think the state that's won out of this is the state that gave them the least, which is the Republic of Cyprus, because it now has a hand to play if it ever chooses to say that it doesn't want the British bases. So that's a caveat. Going back to the kind of stories we tell about activism and mobilization, again, I think in the when we kind of try to see the field in its broader sense and to see the more massive kinds of mobilizations and to kind of also perhaps kind of see activism and mobilization in aggregate, we might it appears easier to come up with a sense of what strategy can mean. But I think what this case shows is that in its very tiny sort of extent, in the microcosm that it is, it shows that grand outcomes can arise, if we want to tell that story of a grand outcome, can arise from very uncertain and quite chaotic processes, in fact.
Right. Thank you. Any other question? Afsania.
Hello, everyone.
Hi, Afsania.
Hello. Olga, thank you a lot for this. Even if you just said that it's small, or the presentation was quite rich, and I was thinking many things, but one you mentioned now also. I was thinking, what if there was any implications or changes or whatever interesting discussions on the status of the colonial status of the sovereign bases in Cyprus from this case within Greek Cypriot or Turkish Cypriot communities. I was also wondering a lot if you, it would be nice to hear a little bit more maybe on the challenges you found by trying to bring together the legal aspect and the ethnographic aspect, because I think exactly because asylum processes are quite complex and you know how it is in Greece also. It's not only, of course, of course, the experience of the people, it's very important, and as anthropologists, we give a lot of attention in that, but analyzing, the changes in the system and knowing the system and knowing the cases like legally, I think it adds a lot to our understanding, as you said also. So, what were challenges maybe, or things that you saw by trying and doing that could help others? And then, okay, there is also a question on the visual aspect, but let's see if other people want any questions, and then we come back if we can. Thank you.
Okay, the first question on Cyprus. I haven't heard of any big discussions on the topic, apart from the informal kind of side conversations that I quoted from this lawyer, for example. There is an opinion by a really interesting opinion by Nasia Hadjigeorgiou on whether this opens the door and what kind of door it opens. And she says that, yes, if the Republic of Cyprus ever wanted to use this in this way, it potentially could, but there are differences with Chagos. So basically what the case does, so it doesn't automatically kind of question the basis, it questions the basis by reference to the International Court of Justice decision on Chagos. There were differences with Chagos, primarily in that what the Republic of Cyprus ceded in 1960 to the UK as the basis, it did so willingly. So I think from what I understand in terms of the law, the big question will be to explain that this wasn't enforced, which is clearer, which seems to be a clearer case to make in Chagos. But Nasia thinks it can be made if the Republic really wants to. The real political problem, I think, is that the Republic will not want to, because the Republic would rather keep the UK as an ally on the Cyprus issue, really, rather than open a battle with it on a plane that I'm not actually so convinced it so much cares about it, to put it crudely, in fact. So that does pose a question about post-colonial states as well, and how, to what extent, this ambivalence of post-colonialism, and to what extent they embrace or not embrace the colonial condition ultimately. So those are the two challenges. In terms of methodological challenges, yeah, I mean, I cannot pretend to have any competence over how a lawyer might read this case. So I'm reading the record, and I'm reading it very carefully, but I'm reading it as a lay person, and not as, so it's not, I wouldn't say it's completely conventional and doctrinal, the reading that I make of the case. But then from various previous experiences, and from having interacted through activism with asylum procedures in Greece, mostly in Greece, actually more in Greece than I did in Cyprus, I was able to understand things from the record, I feel, that I wouldn't have been able to understand if I was coming to this only with my anthropological background, to put it that way. So yeah, there were challenges, and I think what ultimately I tried to do with this case was, without also not having, so I talk about the activists and the activism itself not having a strategy. I can't really also claim that I had a methodological strategy, so I didn't set out to study Richmond Village, saying I'll do so many interviews, and then I'll look at this many documents, and then I'll do this, and then I'll progress like this. It's kind of, it's something that grew rather organically, and I think in that sense that probably was the more ethnographic approach than any other part of the research.
Right, thank you. Well, we're approaching slowly the end of our timing anyway. Is there any last comment or question? Right. So, Olga, thank you so much for being with us and for presenting part of your work. And
it was lovely.
Thank you. Thank you.
And it was lovely to see familiar faces.
Yes, yes, absolutely. So on behalf of the director of our laboratory, Professor Fotini Dimitriou, Eleni Sideri, Anna Moundzoglu, to whom we always say many thanks, Anna, for your contribution every time, and myself, thank you all for attending this first lecture of this year's series of ethnography. So have a nice evening, everybody. Our next lecture is in 2 weeks' time, November 13th, with Professor Sarah Green at the University of Helsinki in Finland. Thank you all very much. Have a nice evening.
Thank
Bye.
you very much.